Welcome. Thanks for coming today for today's program. The law school has brought in through its generosity and its foresight our speaker today, Eric Segall. I'm Steve Sanders. I teach constitutional law, family law, constitutional litigation here. I've known Eric for a number of years. I think we first met at a con law professor conference at Loyola in Chicago, where Eric showed up in the audience for a presentation I was giving and was just incredibly energetic and enthusiastic and supportive. And I thought, this is somebody I want to get to know better. This is somebody who sort of models wonderful behavior as a colleague and as a person in your profession who is thoughtful, smart, provocative, but also incredibly nice and incredibly generous as a person. And part of that is why he's here today. Eric Segall is the Kathy and Lawrence Ashe Professor of Law at Georgia State University College of Law in Atlanta, where he teaches Con Law 1 and 2. It's actually, you have to endure one Con Law class. Their students have to endure two. One class on structure and functions of government, and Con Law 2 is 14th Amendment stuff, and also teaches federal courts, what's known here at this law school as federal jurisdiction. Eric is a graduate of Emory University in Atlanta and Vanderbilt Law School, where he was the research editor of the Law Review, and then clerk for judges of the Northern District of Georgia and for the 11th Circuit U.S. Court of Appeals. Before joining the Georgia State faculty in 1991, he worked for the law firm of Gibson, Dunn, Crutcher as a litigator in Washington, D.C., and also as a litigator with the U.S. Department of Justice. Professor Segall is the author of the book, which he's just spent some time with my seminar discussing, called Supreme Myths: Why the Supreme Court is Not a Court and Its Justices Are Not Judges, as well as law review articles in the Stanford Law Review, the UCLA Law Review, many others. He's also a prolific writer and commentator and blogger, somebody who really takes seriously the idea that law professors should be engaged with the public, that we have a role to play in stimulating debate and educating people about what the courts do and what constitutional law is or what it isn't. He blogs for Dorff on Law, which is a law professor blog run by Michael Dorff at Cornell. His writing has appeared in places from the New York Review of Books to the Daily Beast. He's on XM. He's on Bloomberg Radio as a commentator. We've done that together. And so Eric is lively, provocative, a great speaker, and he's here today to sort of road test what he says is this is the first opportunity he's had to present an extended version of the argument that he wants to make. 8 is enough, as the poster says, why he thinks it would actually be, we'd be better off as a country. The Supreme Court would be more confined to what he sees as its appropriate role if we didn't fill the vacancy left by Justice Scalia's death, if we had a Supreme Court that by nature could be prone to even splits, to an evenly divided court. So let me give you, and welcome to Bloomington for the first time, Professor Eric Segall.
Thank you, and thank you, Steve, for arranging this fantastic day. I've already been able to help teach a class. I have this, and it's really fun. You have an amazingly beautiful campus. I saw a parking garage prettier than any building on my campus, which I thought was impressive. So thank you, Steve, for the invitation. Thanks for being here. It's a beautiful day outside. I appreciate this. So my thesis is going to be that our current Supreme Court, with 4 justices appointed by Republican presidents and 4 justices appointed by Democratic presidents, we have 4 liberals and 4 conservatives. Now, occasionally Justice Kennedy votes liberal and occasionally Justice Baier votes conservative. But overall, we have 4 Republicans, 4 Democrats, 4 liberals, 4 conservatives. And this is perfect. This is how it should be for the rest of time. And I'm going to present that thesis to you today. I'm going to start off with the benefits, the advantages of an evenly divided on ideological grounds Supreme Court. I'll talk a little bit about the pushback I've gotten from this and the negatives of an evenly divided Supreme Court. I will also explain to you how this could be done without a constitutional amendment and fairly simply. So that's the roadmap. But I have 2 caveats before I begin. One is, and I've now done this enough that I know this is a big issue, change is hard. It's really hard. It's hard personally. It's hard professionally. It is just hard. And what I'm advocating for is a serious change in how we think about the Supreme Court of the United States. So when you listen to my, what some will consider to be crazy ideas, I'm a member of American Constitution Society. I am now a pariah for them for this idea. We need 9 is their motto, and they don't like me right now. I hope they'll like me again in the future. But change is really hard. And so I know that's going to be a little bit of an obstacle. But the second thing I want to say before I even start is if you go back to the early 1960s and a law professor named Alexander Bickel, who coined a phrase, the counter-majoritarian difficulty. And what he meant by that was, how do we justify unelected life-tenured judges striking down acts of the legislature or political decisions made by other political actors? Since that time, law professors, court commentators, and judges have literally, burnt down forests trying to come up with ideological, theoretical constraints on Supreme Court decision-making. How do we rein in the justices, given our vague text, contested history, and originalism, and all kinds of other theories on both the left and the right have tried to rein in the justices, and they've all failed miserably. No, the justices are no more restrained today than they were in 1958. In fact, they're probably less so. And my point in saying that is, if we think there might be a problem, and I think there is, with Citizens United and maybe the same-sex marriage decision and Heller and whatever, ideological, theoretical constraints won't work. What we need is institutional change. We need something that changes the nature of the institution. That's what I'm suggesting, because I think we do have serious issues with how the Supreme Court operates. So those are my 2 caveats. So let's begin with the benefits of our current 4-4 deadlocked court. When we saw this last term in several important cases, when the court is ideologically divided along either partisan or just ideological lines, and they see a deadlock coming, they see that they're going to be 4-4, they are going to work much harder to issue narrower, more consensus-type decisions. And that's a really good thing. That is their job. That is what they ought to do. One of the theoretical constraints that smart law professors have put forward in the past is this idea of minimalism. Justice Roberts pays lip service, he doesn't believe in it, to this minimalism idea put forward by Cass Sunstein. It doesn't work. But if it's 4-4, evenly divided in close cases, they will be minimalist, because they will have to be minimalist. They will issue a narrower decision, and they will strive for consensus. As a purely symbolic role model example, that's exactly what this country needs right now. At no point in our history, I don't think, maybe 1960, but I'm not sure, maybe it's Civil War, we are so polarized, we are so ideologically separate, that it would be great to have a national institution role modeling bipartisan sacrifice and agreement on contested, difficult issues that cuts across ideological lines. And if it is 4-4, by definition, to get 5 Supreme Court justices, you have to get one of the conservatives, at least, to side with the liberals, or one of the liberals to side with the conservatives, by definition. And that is only a great thing. I can't imagine anyone taking issue with that. I mean, that's what we want them to do. Law students are often dismayed and surprised to find out that our highest judges don't even ever get in a room and debate with the other oral argument. When the oral argument is over, they go to conference, they vote, and as a group, they never talk about the case again. And in conference, they don't hash it out. They vote, and they may say a sentence or two, but that's it. They don't really hash it out. They hash it out in writing by memo, not even by email, mostly by memo, believe it or not. That's a different conversation. We want them to hash it out. We want them to make consensus, narrower decisions. So those are some of the benefits. But that's not the biggest benefit. The biggest upside to my proposal is that there have been times in American history when an ideologically unbalanced Supreme Court, 5 or more justices in clearly one camp, has changed American society in dramatic ways for no other reason than they could. So from 1930 to 1936, roughly, people debate this now, but somewhere around 200 or more laws were struck down by the Supreme Court involving workplace safety, minimum wages, overtime, child labor twice. We had child labor, horrific conditions in this country, much longer than we should have because of the Supreme Court of the United States. And for 35 years, men who grew up in a different world, in a different society, in a different culture, struck down laws that virtually everybody today agrees should not have been struck down. There are some outliers out there, but most people agree the court erred dramatically, all of which led to court packing plan and all of that. They did that not based on the Constitution. They did that because they could. Some people think the Warren Court for 10 or 12 or 15 years went much too far to the left because they could. I happen to think, and I'll identify as a liberal progressive, I may not believe it, but it's true, I think the backlash to some of the Warren Court decisions really hurt the left dramatically. And why did that happen? Because they could. In every constitutional law case that ever comes before the Supreme Court, the essential issue is when should 5 out of 9 or 6 out of 9 or a majority of 9 justices in Washington impose a national rule on 50 states, the Congress, the President, and 300 million Americans. That's the issue. Common law, you don't hear that very often, but that's the issue. When do we want 5 unelected, life-tenured judges in the nation's capital, all of whom went to Harvard and Yale, to impose a national rule on the rest of us? And I would hope the answer to that is pretty rarely. I would hope the answer to that is only when the Constitution is reasonably clear that they should do that. But that's not our history. Our history is whether it's Dred Scott, whether it's civil rights cases, whether it's Lochner plus 200, whether it's the Warren Court in all kinds of different areas, whether it's the Roberts Court on voting rights, whether it's affirmative action. The answer is they do it when they can. We should make it harder. We should make it harder. And having a permanent 4-4 evenly divided Supreme Court will make it much harder. That's not a theoretical constraint. That's a real life, in your office, in your face constraint. And it's a good one. It's a good one. The other benefits of having a 4-4 evenly divided Supreme Court is, by definition, every decision being 5-3 or more, those decisions will be better accepted by the American people when they see, cross-partisan agreement. And they're more, I think, less likely to be reversed over time. And Lord knows the history of constitutional law in every litigated area, First Amendment, Second Amendment, Fourth, Fifth, Sixth, Eighth, and 14th Amendments, is back and forth, give and take, reversal, whether it's the Commerce Clause, whether it's the Establishment Clause, whether it is gun rights. The Supreme Court goes back and forth, back and forth, back and forth. And that kind of suggests it's not really about law, it's about values. Doesn't kind of suggest it, it shows it. I think this would make it harder for the court to embark upon that merry-go-round of changing its mind. That's a good thing as well. So I think all of those things are obvious benefits of a 4-4 evenly divided Supreme Court. The biggest pushback I get is a lot of hand-wringing about uniformity. That the whole purpose of the federal court system and the Supreme Court sitting on top is to maintain the uniformity of federal law, and we can't have different constitutional rules and different statutory interpretation results in Arkansas and Texas and California and New York. So, Professor Segall, you're nuts. We need the top of the pyramid, and if it's 4-4, there will be a lot of cases where uniformity is put at risk. And my answer is twofold. My most important answer is no, that's wrong. It's empirically wrong. 99.8% of federal cases never get to the Supreme Court. Well over 99%. So we don't care about uniformity in over 99% of federal cases. And when it comes to state cases, it's 99.999999999. So we don't really care that much about uniformity. The Supreme Court takes about 75 cases a year now. Of those 75 cases, roughly 20% are 5-4. So that's 15 cases a year, give or take 1 or 2. Of those 15 cases, almost none of them raise uniformity issues. That's not to say people wouldn't want, some people in Texas want a pro-choice rule, some people in Texas want a pro-life rule, same thing in New York, but uniformity isn't the issue. Actually, there are very few constitutional law cases where uniformity is important. Same-sex marriage might be one of them, but there are very few. There are some statutory interpretation cases involving antitrust and securities maybe. There used to be antitrust cases, there aren't anymore. But there might be some, but again, very, very rare. So my first point is, all the benefits I outlined, I'm not suggesting I have a perfect solution. I don't have to prove my proposal is perfect. I only have to show that it's better than what we currently have. And to the extent we lose a little bit of uniformity, a little bit of the time, I'll lose that and not have Lochner for 30 years, and not have Shelby County, and not have Citizens United. So I'm willing to say that. The other thing is, Rick Hasten is our leading election law expert in the country, and he and I are friends. He's at UC Irvine, and he's very worried about an election crisis. And without the Supreme Court sitting on top, what are we going to do? What are we going to do if it's 4-4 and the country is coming down to it? And how do we have a peaceful transition of power and all that? And I have several responses to that. First, well, I don't think Bush versus Gore was necessarily the best way of resolving that controversy. I would like the Florida Supreme Court to have resolved that controversy. But leaving that issue aside, here's what I do know. And I'm confident of this. If there is a case where the uniformity interests are incredibly important, and that could be the case in an election law crisis. If there is a case where we have to have a national rule no matter what, or we'll all go up in flames, they'll find a way. They will. They will find a way. Because the Supreme Court cares very much about its own institution and about the country. And if the country is at stake, Justice Kennedy will flip, or Justice Baier will flip, or maybe even Justice Roberts will flip, which in fact he did, when I think he thought the country was at stake in a sense. So I'm not worried about that. These are people, we're not talking about radicals on the court. We're talking about people who have a deep sense of loyalty to country and institution. So the uniformity interest, I think, is extremely overstated. And I had the data. 99.9% of cases don't get to the Supreme Court. So it can't be that important that the Supreme Court decides cases. It just can't be. And the other thing about that is, if we're going to have that kind of crisis, it would be better if we have a bipartisan Supreme Court decision. And this increases the odds of that. One proof of that is we actually didn't have that in Bush versus Gore. But people on the right for a long time suggested that decision was really 7-2 because there were 7 votes that there was an equal protection problem in Florida. And Justice Scalia went around the country his entire career saying, get over Bush versus Gore. There were 7 votes. There weren't. There were 5 votes to stop the recount, which is all that really mattered. But the idea that there could have been 7, Scalia saw as a huge saving grace. And in that sense, maybe he's right. Maybe he's right. Maybe if we're at that moment of crisis, Al Gore did the right thing. Does anybody in this room think Donald Trump will do the right thing in that situation? But he might have to if it was bipartisan. So I don't know. The other pushback I get, which is less interesting and more practical, is, okay, you're right, but so what? It can never happen. Great idea. Great. The person I blog with, Mike Dorff, wrote yesterday, that's a great thought experiment, but it can never happen. It absolutely could happen. And without that much difficulty. So there are 2 things that have to happen. First, the number 9 for justices is not in the Constitution. It's in a law passed in 1869. It's up to Congress. They could pass a law saying 8. It started with 6. And by the way, the German Supreme Court has 16 judges divided in 2 panels of 8. They do quite nicely. The German Supreme Court is considered one of the successes of European Supreme Courts. They have an even number of justices. Anyway, so Congress has to change the number to 8. That's just passing a law. And they could override a veto if they had to. That's not that, I don't think that's a huge, changing the number isn't the hard part, right? The hard part is how do you make it ideologically balanced? Because an 8-judge Supreme Court with 7 Democrats and 7 liberals, although I would like that in my political hat, doesn't serve the purposes I'm talking about. Not that hard. Not that hard. The Senate Majority Leader and the Senate Minority Leader could raise their hands in unison in a moment of refreshing bipartisan agreement, which they haven't had in 10 years, and say, it is in the long-term interests of this country, of this institution, this country, and the American people to have an evenly divided Supreme Court. So here's what we're going to do. When a Republican Supreme Court justice retires or dies, the president must send over a Republican, whatever his political party. And where a Democratic president has an opening with a Republican justice, who send over a Republican. Now, the president can send over whoever he or she wants. Haven't said that in years, but he or she wants. They can do that. And the Senate is within its constitutional prerogative to say, sorry, we don't want that person. You must send over someone of the same political party. And I have a little escape hatch where if the president sends over an independent or someone for whom their political party identification is not clear, then maybe 3/4 of the Senate could approve. I think that works. So they announced that, and the Senate does this all the time. This would just be one more thing the Senate does like this. The filibuster, requiring, in effect, in different ways, 60 votes to pass a law instead of 51, went on for over a century by bipartisan voluntary agreement and only ended a couple years ago. 100 years or more they enforced the filibuster voluntarily as a bipartisan thing. It wasn't binding on future Senates. It wasn't written in a law. There was a rule about it, but they just did it voluntarily. We currently today have something called the blue slip process. If a judge from Georgia, if a nominee from Georgia is nominated to the Court of Appeals in the 11th Circuit, and one of the senators from Georgia opposes that person and files a blue slip saying that person is basically dead in the water. Even if 95 senators want that person. That's informal. That's really informal. That's not even in the rules. But it has been adhered to consistently by the Senate in different degrees for a very long time. They do this all the time. The whole idea of committee seniority and assignments in the House and the Senate is voluntary. Both parties agree to this structure and system. It would not be a step for them to say, we think the Supreme Court should always be in the form of a divided government. And by the way, Americans love divided government. Our entire system is based on divided government. We separate powers at the federal and state levels in the hope, Justice Kennedy calls it the counterintuitive but persuasive idea, that two governments will protect liberty better than one. I actually think that's probably right to some degree. We separate powers at the national level. And we do all of this to disperse decision-making authority. But at the same time, we share powers so that when the government needs to act efficiently, it can. And I'm a good liberal, so I want a lot of government. But the constraint of divided government is something we feel very strongly about. The analogy is not perfect. It's not a perfect analogy. But I think it fits. If we disperse and divide power among 8 justices evenly, again, 80% of the time, they're going to do what they've always done, which is decide cases, not 5-4. They have plenty, it's shared powers. They can be efficient. But when things get really tough, when we have the most politically contested cases, when we should be asking at that moment in time, do we want our most difficult social, economic, political issues decided by 5 lawyers in Washington? If that's who we're going to delegate this to, we want at least a little bit of bipartisanship. At least a little bit of saying this was a team effort. This wasn't 5 justices imposing their will because they could, which is our current system of government and has been since 1803, pretty much. I even think, and I'm going to be a little more humble about this part of it, I think our nomination process, which is currently an abysmal state of affairs. Justice Kagan, before she was nominated, wrote a law review article calling it a charade. She was right. It is. It's terrible. The kind of justices we will get. What's going to happen if a Republican president has to nominate a Democrat? He's going to find a conservative Democrat. And if a Democratic president has to nominate a Republican, he's going to find a liberal Republican. And this can be gamed. The system can be gamed, and we can have stealth candidates. But that's our current system, right? Souter, Stevens, Blackmun, White, all stealth candidates in a significant degree. So I'm not creating a perfect system. I'm creating a system better than one we have now. And the idea of the cooperation that would have to go on between a Democratic president and even a Democratic Congress for that matter, committed to a 4-4 evenly divided Supreme Court is again exactly the role modeling we want. It's exactly what we want our young people to see. The benefits, and one way of looking at this, and then I'll stop, is through Rawls's kind of veil of ignorance. If I knew I was going to have, and this is my current disagreement with the American Constitution Society, which I feel very strongly about and I'm a loyal member of, but this is my current disagreement with them. If I knew I was going to have 5 Justice Brennans or Souters or Johnsons for the rest of my career, I might say, well, principle must yield to expediency, and I'm happy with that. But I don't know that. In fact, history tells me I am much more likely to get anti-progressive, conservative Supreme. That's not why I'm doing this, but just as a matter of liberals being mad at me for this moment of time, we don't know what the next 50 years are going to bring. I know what the last 200 years have brought. It brought Dred Scott and Plessy and civil rights cases. It brought Lochner plus 200. It did major damage to affirmative action. And the victories that the left thinks it has with Brown and Roe had major, major, major drawbacks and create all kinds of other problems for our political system. So I don't know what's going to happen in the future. So I'm willing to say, let's put my political values aside. I think I'm right about abortion. I'm pro-choice, but I could be wrong. I think I'm right about guns. I'm anti-Heller, but I could be wrong. But I'm willing to say a 4-4 evenly divided court who will have to work much harder to reflect on these very tough questions is a better system. And my very last point is this. Where they are 4-4, where they really can't decide, the case gets sent back to the Court of Appeals. And as if the court hadn't decided the case. And what happens there is somewhere, I'm not sure the exact number, but hundreds of Court of Appeals judges, most of whom are qualified and well-meaning and try hard, who are much more educationally, politically, socially diverse than our 8 or 9 justices in Washington, will get the final say. And the rules may be different in Texas and New York. The rules may be different in Alabama and California. But you know what? If we can't get one justice to change sides, if they're really hopelessly deadlocked at 4-4 on a major issue facing our country, then maybe, and I'm no states' rights person, but maybe the rules should be different in Alabama and California. Maybe that's telling us something very important about my initial question, which is when should 5 out of 9 unelected, life-tenured justices get to impose their policy preferences on our most important issues on 300 million Americans? And maybe the answer is at least there has to be some modicum of bipartisan agreement before they do that. Thank you very much.
Eric and I talked about whether I would do any sort of response or commentary, and I don't really want to do that. I will ask the first question, and then we've got the microphones for your questions as well. We have plenty of Q&A. Actually, I'm going to ask 2 questions. First, I think this is related to your point about uniformity, which you say isn't that important, but the kind of judicial minimalism that this would lend itself to will also mean you'll get very narrow, limited, fact-specific decisions. It's sort of one case at a time thing, which you think is a good idea. Is that, in principle, a good idea for a precedent-based legal system where lower courts, on recurring issues like aid to religious schools, prayer, various permutations of affirmative action. Lower courts need clear guidance in order to function. It seems to me with this kind of system, you have to keep coming back to the Supreme Court. Okay, you said this much, but now we want to go here. Can we do this? You have to keep asking Mother May I, rather than giving clear guidance to lower courts to apply precedent. Second question on a different issue is, I'd like to hear a little more how you would police, how you would enforce, how we know about nominees' political affiliations. I guess I'm a little uncomfortable that we have to force nominees to the Supreme Court to wear a Democrat or Republican label
on themselves, hang a sign around their neck. Is that a good thing? I would hope that many people are very complicated. They may change parties over time. They have views that are difficult to pigeonhole. They are genuine independents. So say a little more about this idea about, we just go to 3/4. Well, who adjudicates that? Who decides when we have a case where somebody doesn't have a clear party label? Why is it a good thing to force people to pigeonhole themselves into our existing political parties? What it means to be a Republican is a much different thing than it was 20 years ago. Flesh that out a little bit.
Okay, I'll take the second question first because the first one raises really hard theoretical issues. But the second one, I have a couple of responses. Our current system is broken for nominations. So again, all my system has to be is better than the current one. So I don't have a perfect way of implementing it. But I think I would never force a nominee to identify themselves as a Republican or a Democrat, but most would. In fact, maybe Justice Stevens, I'm not sure, I think he was Republican, but I'm not sure he would. He may have been independent. But he's the only one. I mean, unless someone else? Other independents? Okay. So I think that already happens, and that's not that big a problem. If they don't want to identify, then no, they have to get a 3/4 vote or a 4/5 vote or pick something else. And I don't think that's terrible. We're stuck with the two-party system. Now, maybe this whole election will change all that, but it's been a long time. We're stuck with a two-party system. Most of our justices identify as one or the other party. As far as them changing over time, they do that anyway. So my system is no better or worse. I don't think someone is going to... The odds of becoming a Supreme Court justice are incredibly small, no matter how talented and great you are. The timing has to be right. Everything has to be right. I don't think someone at age 30 is going to start planning their way to the Supreme Court and hiding their politics. Now, it turns out, I'm going to get in trouble for saying this, I'm going to say it anyway. I mean, Justice Scalia on the D.C. Court of Appeals absolutely made decisions to the right of Judge Bork, so he would get the first appointment. I think that is just a well-established thing that we know. But he was 40, that wasn't when he was 30, and again, that's incremental. He just wanted to be more conservative than Bork. He didn't want to be. So we will know most of what. Almost everybody who's been nominated to the Supreme Court recently, with the exception of maybe Justice Souter, had a very long record of what they were. So we'll know that. The Federal Election Commission, which many people think undercuts my argument, but I think supports my argument, has to be 3 Republicans and 3 Democrats, has to be evenly divided, and there's no problem identifying those people. So your issues don't bother them. Now, some people say, but the Federal Election Commission is an unmitigated disaster because they never do anything. And that's a fair description of the Federal Election Commission. But there's a huge difference. There is no lower court of federal election. If the Federal Election Commission doesn't do something, the issue goes away. If the Supreme Court doesn't do something, because they're 4-4, Judge Posner in Chicago and Judge Wilkinson in North Carolina and Judge Kaczynski in California and a bunch of other incredibly highly talented lower court judges get to decide, and we get a final decision. One of the great myths of American culture is we need the Supreme Court to have final decisions. No, we don't. In fact, 99.9% of the time, we don't get final decisions from the Supreme Court. We get them from someplace else. So I think you raise interesting and hard questions about the process. I've been on this kick for about 4 months, so I haven't worked out all of the wrinkles. But I think our current process is broken. This wouldn't be that much harder. And I would never make anybody identify their political affiliation if they didn't want to. But I also think they'll want to get a seat in the Supreme Court. So I'm not too worried about it. Your first question. Yeah.
It seems in part to me that maybe one reason the Supreme Court doesn't have to take more cases is, in many areas of law we have clear precedents for the lower courts to apply. Wouldn't there be at least some increase in the number of cases that have to go to the Supreme Court? Because if we have all these closely divided, narrowly decided cases, there would be much more disagreement, more circuit splits in the lower court, more of the kinds of things where the Supreme Court eventually does have to step in because they didn't give the clear guidance the first time around.
I think if Court of Appeals judges know that this is one of those cases that is likely to go 4-4, which I'm not sure they'll know a lot of the time, but when they know that, I think they will pay more respect to their sister court opinions for exactly that reason. So that's one thing. But I do think we disagree, and I think I'm right, about the history of constitutional law in this country. I think David Strauss at Chicago has it exactly right. Our history is not what you describe. It's not major Supreme Court case, lower courts fall in line. It takes often decades for a line of Supreme Court precedent. So you mentioned parochial school aid. I litigated parochial school aid at the U.S. Department of Justice. And I was going to tell the story to the class and never got to it, so I'm glad I can tell it here. When I got to the Department of Justice, I had a case in California and Missouri and New Orleans involving a federal statute that provided aid to parochial schools. And I just come from private practice. I kind of had a thought I would be a con law professor someday, but didn't know. And I was so excited to have a First Amendment case about the Establishment Clause and what local school districts and the federal government could give to parochial schools. I'm not making this up. When I took that case, the rule in this country was that under the First Amendment's Establishment Clause, the government, state and federal, could give textbooks to private religious schools. It was secular textbooks, math, English. They could give secular textbooks. And that was it. I'm having a flashback because we were on this panel together 30 years ago or something. But anyway, they could not give maps. This was a constitutional rule. Books, yes. Maps, no. Talk to me about atlases for a minute. The atlas is okay, but pulling the map out of the atlas, unconstitutional under the First Amendment. And that's just the beginning of the nightmare of the different and varied rules we had for this question, which admittedly is a very difficult question. But their solution was preposterous. That's the history of constitutional law. So take the big issues. Affirmative action. Quotas, no. Wink and a nod, yes. Do we really have quotas? Yes. Most schools do, indirectly. It's not clear rules. We almost never get clear rules. And of course, Scalia's hobby horse for many years, half his career, was we need more clear rules. So, no, in fact, what we have today is very little guidance to lower court judges. And I think that may not even be a terrible thing. Because these are incredible. The parochial school aid issue is really hard. I'm a separationist. I'm a real separationist. I would never vote for a statute that gives money to private religious schools. But as a First Amendment matter, I don't know. Can people disagree about whether kids should get good equipment and good books wherever they're in school? Those are hard issues. I don't think we want 5 judges issuing this really clear, broad rule at one moment that tells us the answer to that question. I want Judge Kaczynski to think about it. I want Judge Posner to think about it. I want it to filter around and debate it. And that is the history of constitutional law. It is almost never the case that a major constitutional issue gets litigated and boom, clear rule. It takes decades. So I don't think my system's any different.
So this is being recorded for the YouTube site. So if you have a question, please use the microphone.
Hi, my name is Inge van der Kruijsen, and I'm not exactly, just as a caveat, I'm not exactly in agreement with you.
No one
but
is.
I have I wouldn't think so. So I have a question. If that's your reasoning, that there should be a compromise, which is I think a great idea, why do you only propose this for the Supreme Court and not for the Circuit Court, since they decide 99.8% of the cases you're talking about? And if that's the case, do you think that the Circuit Courts, the individual members, and the courts as a whole are really loyal to the court's system and in the same way as the Supreme Court justices, and especially Chief Justice Roberts are? Because I'm asking the question because I have the impression, but it's under the current system, that they are their loyalty to the institution of the court is a little different from that of the Supreme Court.
Thank you. Those are great questions. On the first one, I'm in favor of term limits for Supreme Court justices, strongly in favor of it. And then I'm asked about other federal judges, all of whom have life tenure. And my answer is I'm really bad at math. And I think term limits for lower court judges gets very complicated, because what do you do if it's 500 or 600? It gets and even people who've studied this, it's very complicated. The same is true for this. I think having 4-4 on the Supreme Court is not hard. Having every court of appeals evenly divided is more challenging, but I'll go for that. You convince me. I'll vote for that. I think that takes up a huge amount of time on the part of the Congress. that maybe the Congress should be doing other things, or maybe not, or they could delegate it. But I don't have a problem saying that the issue is going to be the phasing of it out, right? I mean, that's going to be difficult, but I'm in favor of that. I think all the reasons why it's good. Now, I will say it's much less important. Just like term limits are less important for Court of Appeals judges, term limits are much less important. I mean, equal balances, because it's really true that 98% of what Court of Appeals judges do are not front-page constitutional law cases and don't affect the whole country. In fact, they almost never affect the whole country, whereas, virtually every constitutional law case, which is half the court's docket, give or take, affects the whole country. So I think the stakes are very, very, very different. Your second point, I know a lot of lower court federal judges, and I know a few incredibly well. And I think they have views of the Supreme Court that are very critical because they know what I know, which it's not court. So it's a different thing. It's a veto council. But their loyalty to our judicial system, to the rule of law, to doing the best they can, if anything, I think exceeds what the individual justices feel for one reason. And it's a big reason. And if you know any CEOs, my dad was a CEO. I love my dad. But the company was him and he was the company. I mean, he talked about the company as I, I mean, and he talked about giving governmental officials unreviewable, in effect, unreviewable power for life is a terrible idea. And that changes the nature of how they see themselves. And although Court of Appeals judges have a lot of power and for life, it is not unreviewable. So Judge Posner, who is publicly against Heller and thinks Heller is a fraud and a fiction, votes to strike down an Illinois gun law, which he would never vote to strike down if he were the last decision maker, because he thinks the Second Amendment doesn't apply to individual right to own guns. But he struck it down. Even Judge Posner, who is the most independent rascal there is in the federal judiciary, he voted to strike it down because his job was to follow the Supreme Court. The Supreme Court's job is never to follow the law. They can just change the law anytime they want, and they do it all the time. It's much more important to place limits on their discretion than the Court of Appeals judge's discretion. So I'm for your proposal, but I don't think it's necessary to accomplish a lot of what I want to accomplish.
Hello. Thank you so much for being here today. I have a question regarding the goal of bipartisanship, because if, let's say hypothetically, the majority party of the Senate is strongly Republican, do you fear that maybe they will only approve of an extremely strict constructionist justice so that they'll just hunker down and refuse to negotiate so that when they do decide to rule, it will generally rule in the Senate's favor?
Well, that's our current system. I mean, that's our current state of affairs, obviously. I think there was a informal understanding in the Senate for 2 centuries that presidents get to nominate who they want to nominate within broad constraints. So, yes, Judge Bork was outside the mainstream, but his seat was the pivotal, swing vote, so no. But generally speaking, presidents get, if they don't appoint rascals, they get the nominees they want. I think but that's all just cooperation. I think we could go to a different system of cooperation, where presidents, get to nominate moderates of the opposing party. So we're more likely to get Souters and Blackmans and Stevenses and Whites than we are to get Ginsburgs and Scalias. I think we're a better world with 9 Justice Souters than either 9 Justice Scalias or 9 Justice Ginsburgs, even though I agree with Justice Ginsburg 99% of the time. I think we're better off with a world of 9 Justice Souters. I think we have a better chance of getting 9 Justice Souters under my proposal.
Hello. I've been reading about this for a few months too, and I am totally in agreement with you.
Wow, thank you.
But I was wondering, how much kind of mainstream support is this getting? Is it getting any steam behind this idea, or is it just kind of confined to academia?
So it turns out, what's the question? Was the ad? It's just me.
Or just academia in general.
Among constitutional law professors, here are the universe of people who I know agree with me. I know thousands who don't. Not thousands, but hundreds who don't. There's a professor at Pepperdine, Barry McDonald, who wrote a New York Times op-ed about 2 weeks after I wrote a New York Times op-ed, where he agrees with this. That's one. Professor Mark Tushnet of Harvard, who's a famous radical, left used to be radical, now he's just very far left. He has sympathy for this. Professor Sandy Levinson of Texas has some sympathy for this, and that's it. Let me try to explain why, though. And this may get me in trouble with some. But I do think, in addition to change being hard, I do think it's very hard right now, and Mark Tushnet did say this to me, even though he has some sympathy for the idea. It's hard for liberals who have seen a conservative court now since roughly 1972 to give up the ghost at the moment when they might win. And I get that. And it hurts. And I get it, and I understand it, and I feel that pain. So that's one reason. I think a more ingrained problem, though, and I say this in my book, Why the Supreme Court's Not a Court, is despite the degree of legal realism out there among most constitutional law professors, they will not go all the way with me and say the court is not a court, for example. And the reason I think they won't do that is once we recognize that, then constitutional law professors become much less important. We really do. Because why should we, in my world, abortion and affirmative action and many free speech, not all, but many free speech claims would be delegated to the people, and we wouldn't have as much to talk about. And I think that's very threatening. I think one of the most threatening aspects of making the Supreme Court much less powerful is there's a whole economic chain of events that are really reliant on the Supreme Court being in the front of the news every day. Dahlia Lithwick is a reporter for Slate on the Supreme Court. She is one of the most talented Supreme Court commentators in the United States. I think she's brilliant. I think she's wonderful. We're friends. I think she's great. Dahlia, I think you're great. She is so against this, and she would never admit it. But I think part of it is her job becomes incredibly more difficult if this comes into play. And she has said in print, in Slate, and other places many times over the last 5 months, oh my God, my job's so boring. It's so hard. There's nothing to write about. Garland's the forgotten man. I get that. I do. I get that. But my answer is you're really talented and you can write about anything and it'll be entertaining. So write about other things. And she hasn't done it well. I think that's what's going on here to a significant degree. I will say, I'd like to think I may be wrong about my universe of people because I think one of your professors might have some sympathy for my proposal. So I'm picking it up. I will also say one more thing. There's going to be a extremely highfalutin conference at Pepperdine in April with not people like me, but people like Akil Amar and Ernst Chemerinsky and the top of the famous people in their profession. The odd man out there is going to be me. But this idea is going to be discussed there. And whether or not Garland gets nominated or confirmed between now and then, the whole conference is devoted to what structural changes should we make to the Supreme Court. I'm excited about that, and maybe we'll get some adherence along the way. I don't know. I'm not optimistic this is ever going to work, but I thought it was worth a try.
I actually happen to have just a really quick question. So you said that the Supreme Court is not a court. I feel like your argument right now about why we should have a 4-4 court hinges partially upon your basic idea of why the Supreme Court is not a court at all. I was wondering if maybe you could just maybe make a paragraph, like real quick explanation of why it isn't.
Sure.
Because I've heard it called a 9-person black robe junta. And I kind of tend to agree with you on that. Actually, as somebody who's a little bit more conservative.
I can do it in 3 minutes.
I think we're a microcosm right now of why can't we do a 4-4 court?
Okay. I can answer that question in 3 minutes if I have 3 minutes. Do I have 3 minutes? Okay. Judges always have discretion. Traffic court judges, superior court judges, all judges have discretion in the open spaces. Law can't completely constrain judges. But there is one thing we insist judges do. All judges in all Western societies take prior law seriously. It doesn't mean it's going to decide the case, but take it seriously. And Judge Posner did that when he overturned Illinois' gun law, even though he thought it shouldn't overturn it. So take prior law seriously. The data is overwhelming that the Supreme Court does not take prior law seriously. And that's a question of degree. But my book is full of 300 pages of examples where it's impossible to look at decision A and think they took decisions B, C, D, E, and F that came before it seriously. And that's exactly what we would have expected to happen when we give governmental officials unreviewable power for life. They will do what they think is best. And maybe they should. I'm not even criticizing that. But that's not what judges do. And that's why it's not a court.
Eric, I am sympathetic to the idea. Apart from constitutional law professors who don't have a whole lot of influence, what would be the political conditions in which this idea might be viable? It seems to me that the best window is already closed, which would have been after Scalia, in the current time frame, after Scalia's death, before it became relatively clear that Clinton's going to win the election, when there was true uncertainty about the composition of not only the presidency but also the Senate.
Oh, I think the answer to your question is, if Hillary wins, if not, nothing I say matters because we're in such trouble anyway. If Hillary wins and the Senate stays Republican, Senator Lee just 3 days ago, for the first time, any Republican has said this, he's on the Judiciary Committee, said Garland may not get it anyway. If the Senate or any Democratic nominee may not get it. I think if Hillary wins and the Senate stays Republican, I'm a little nervous about this because I think I have to be honest about this. Where I, for example, sometimes this happens, we're called to Congress to testify about all the benefits of this at the behest of the most conservative Republicans in the Senate to avoid nominating a liberal Democratic, I'll be nervous. I mean, I'm not, but I would do it. That's the window right there. And it'll be looked at. And so one of the things that Mike Dorff said to me in response to my proposal was the Republicans can't do it because it would be rewarding them for the shameful way they've treated Garland. And my response to Mike, I haven't made it formally, but my response to Mike is that American people forget that in about 3 weeks. I mean, I don't think that's a problem. Yes, it's reporting Republicans for engaging in a kind of stonewalling that's never been done before. But I would twist that and say this wasn't their goal or their motive, but the result of that's a really good thing. And let's not worry about their partisan motivations. What do we end up with? With an 8-person evenly divided Supreme Court, and then I go through my thing. And I think, if we knew Trump was going to win, ACS would be on my side like this. And that's the problem. And that's the problem. So not knowing what the future holds, I'd like to think this is a neutral, non-ideological solution in the sense of partisan politics. It does reflect my view of the Supreme Court, which is that over time it's done more harm than good. But other than that, I think it's nonpartisan.
I think we have time for one more question. Anybody? Oh, sorry.
So you brought up a scenario where you could envision the Republicans, if they win the election and the presidency and the Senate, proposing this sort of idea. My question is, if you have...
if the Republicans win the Senate but lose the presidency.
But lose the presidency.
If they win the presidency, they won't do it.
So my question is that if you have, in 2, 4, 6 years, when if the Senate changes or the presidency changes, what stops, if you have a program like this that is clearly made for partisan reasons, what stops Democrats from doing?
Right. I have a slam dunk
doing
answer.
that.
I have a slam dunk answer. There have been times in American history, many of them, where both houses of Congress were controlled by the same political party, and they still voluntarily went with the filibuster when they didn't have to. So there have been many times in American history where the Senate had 52 Democrats or 55 Democrats or 52 Republicans or whatever, and they didn't have a filibuster-proof majority, and they voluntarily agreed to go by that when they didn't have to. And that changed a couple of years ago. But we had more than, I think, a century and a half and the reason was mutually assured destruction. They knew that someday they would be the minority party, and they knew someday as the minority party they would want the filibuster. We've already had, same thing with the blue slip process, exactly the same with the blue slip process. If they did it for the filibuster and they did it for the blue slip process, they could do it for this.
Okay. Yeah.
With the filibuster, though, someday is usually 2 to 4 years, whereas with the hypothetically you could have control of the Supreme Court for 20, 25 years.
That's why this is more important. That's one thing I didn't get to was the absurdity of our nomination process now, which is random. Justice dies, politically timed retirements. We don't have any control of who sits in the Supreme Court now, really. That's crazy. If Justice Thurgood Marshall lasts 8 more months, we never get Justice Thomas, and we never get Citizens United, Heller, and the voting rights case. So that was all because Marshall got sick a little bit too soon from the left's perspective. Under my system, that wouldn't matter anymore. Now the politically timed retirement strategy goes away. The randomness of death goes away. Because if you die in office or you retire because you're sick, because your husband has Alzheimer's, Justice O'Connor's case, or if you're Marshall and you don't hang on long enough, you get replaced by somebody who is, reasonably close to your political proximity. And that takes the randomness out of who sits on our highest court, which is crazy.
Eric, thank you.
Thank you.